Friends, we will discuss polity questions that have been asked in UPSC. So our first question is, when and where was Panchayati Raj first started? Panchayati Raj was first adopted in Nagaur district in Rajasthan on 2nd October 1959. It operates at village, block and district level. Now, the second question is, what was so controversial about 42nd Constitutional Amendment 1976? It was enacted during emergency. It gave primacy to directive principles over fundamental rights. That is, it provides for curtailment of fundamental rights, imposes fundamental duties, changes basic nature of constitution by making India socialist secular, adding these two words. And it also made change in preamble by adding unity and integrity of nation instead of unity of nation. Article 14 and Article 19 were made subordinate to Article 39.p.c. It was brought into effect based on the recommendation of Swan Singh Committee. Swan Singh was the Minister of External Affairs during that time. Opponents called it convenient camouflage because of various reasons. First of all, ancient disputes were removed from the purview of courts. Any law passed in pursuance of directive principle of state policy was immune from scrutiny by Supreme Court, gave Parliament unrestrained power to amend any part of constitution without judicial review. It transferred more power from state government to central government, eroding India's federal structure. Curtailment of Supreme Court powers and moved the political system towards parliamentary supremacy, something that is observed in United Kingdom, Israel, and New Zealand, wherein legislature is supreme over executive and judiciary. It contradicts separation of power. It gave sweeping power to the PMO, Prime Minister's Office, and removed all limit on Parliament's power to amend Constitution under Article 368. Now we will move to the famous case Golaknath versus State of Punjab, 1967. Golaknath judgment restricted authority of Parliament to amend the Constitution so as to damage the basic or the essential features. Family of Therefore, the Parliament could not curtail fundamental rights in the Constitution. The background was family of Henry and William Golaknath filed a petition under Article 32 challenging the 1953 Punjab Security and Land Tenure Act on grounds of violation of Article 19F, 19G, and Article 14. They also sought to have 17th Amendment, which placed Punjab Act in 9th schedule, declared ultra vires. The judgment was constitutional amendment is ordinary law within Article 13, subsection 2. Article 368 contained only explanation and procedure to amend the Constitution. Constitution actually derived power amend from entry 97 of list 1, that is the union list of schedule 7 of the Constitution. Any matter not enumerated in list 2 and list 3, amending power of article 245, 246 and 248. The doctrine of prospective overruling was first invoked in this case by Chief Justice of India Kokka Subbarao, and the phrase basic structure was first introduced by M.K. Nambiar and other counsels while arguing for petitioners in this case. But it was only in 1973 the concept surfaced in SC verdict. So, moving on to the next famous case, that is the Keshwanand Bhartiyan state of Kerala. In this case, Justice Hansraj Khanna asserted constitution possesses certain basic structure, basic principles, basic values. Article 31C, added by 25th Constitutional Amendment, was struck down in this judgment. Changes introduced by 42nd Constitutional Amendment Act was struck by Minreva Mills versus Union of India, which added judicial review, balance between fundamental rights and DPSP as basic feature. So we can summarize on basis of various SC verdict what actually constitute of basic structure doctrine in the constitution, which was borrowed by Supreme Court of Bangladesh in 1989. It includes judicial review, independence of judiciary, effective access to justice, power of Supreme Court under Article 32, 226, 136, 141, and 142, limitation upon amending powers conferred by Article 368, objectives specified in preamble, sovereign, sovereign secular democratic republic, freedom and dignity of individual, unity and integrity of nation, rule of law, principle of separation of power, balance between fundamental rights and directive principles, economic and social justice, parliamentary system, free and fair election, and federalism. So we will now discuss the important Supreme Court decisions. Before that, we can discuss uh, what were the power of Supreme Court under the various articles. Like Article 32 gives right to move Sup- to Supreme Court by appropriate proceedings for enforcement of right conferred in this part, that is Part 3, by in guarantee by Article 31, 32, subsection 1. Article 226 gives power to High Court to issue writs. Article 136 gives special leave to appeal by, by Supreme Court. Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in territory of India. Whereas Article 141 talks about law declared by Supreme Court to be binding on all courts within the territory of India. Article 142 talks about enforcement of decree or order of Supreme Court. Now, back to the Supreme Court judgments. Shankari Prasad versus Union of India. The first constitutional amendment was challenged on the ground that it violates Part 3, which contains fundamental rights. SC upheld it. SC under Article 368 said Parliament has power to amend any part of the Constitution. Same judgment was passed in Sajjan Singh versus State of Rajasthan 1965 judgment. In Golaknath versus State of Punjab, as we have discussed earlier, SC overruled its earlier decision. No, Parliament has it told Parliament has no power to amend Part 3, that is fundamental rights of Constitution. 368 only lays down procedures to amend the Constitution and does not give absolute power to amend any part of the Constitution. Indira Gandhi versus Raj Naran 1975, SC reaffirmed its concept of basic structure. Ihoto Holohan versus Jackie Lu in 1992, free and fair election was added to basic structure. Indira Sahani versus Union of India 1992, rule of law was added to the basic structure. S.R. Bomai versus Union of India 1994, federal structure, secularism, social justice, unity and integrity of India, socialism, judicial review was reiterated as basic feature in the constitution. That is all for now. We will meet again soon. Thank you.